And we're live.
All right. Hi, this is Kurt Barone,
And Brad Pinsky.
and I am coming to you from Bogota, Colombia today. I'm still a little bit jet lagged, but we're here to talk about Fire Law Roundup
Excellent.
for, let's see, it's August 25th of 2025.
Okay, so we have some short stuff and some screwed up stuff as usual. I guess it's a normal day. Okay, let's start in Fayetteville, Arkansas, not my near hometown of Fayetteville, New York. But Fayetteville, Arkansas, and we like to see this, right? We have a firefighter Bill of Rights that's been adopted. It expands upon something they did previously in the year where they came out with like a non-mandatory compliance for
Yeah, the
fire
state, and I
departments.
think this is really good. And let me just say up front, the folks who are looking at, I know there's a number of states that are looking at Firefighter Bill of Rights. This is a pretty good one. There's a few tweaks that I would add if I was, involved in lobbying for it. But overall, I would give this one a B plus. It's a good policy. But the state adopted the sort of template, but they left it up to each community whether or not they're going to adopt it. And
Right.
Fayetteville was the first one that adopted it.
And now we have a mandatory, right? We have a mandatory statute look, firefighters' Bill of Rights are due process. They're basically, I mean, there's a lot of versions, as you're saying, right? The way they're
Yeah.
drafted,
Oh,
but
yeah.
this one is mostly a due process, as is New York's and many others. And so it goes through, it says, listen, you have the right now at the beginning of an investigation to be informed of the nature of the investigation, the
Well,
authority of the
no,
investigation.
no, 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 no. If that says that, that's not
Oh, it
right.
does. Yeah.
Uh, oh, no, no, no. Now, see, now this is where it gets a little confusing. Now,
Okay, turn it back
it
to you because
says
now I'm
at the
confused.
start of the interrogation. That's not the start of the investigation.
Oh,
So
I'm
we
sorry. My right.
No, no, no,
Start.
that's okay. Brad, when I was writing this, I was confused going back and forth because it's really important. And this has been a problem in other fire departments as well, where people are saying, you didn't tell me I was under investigation. The Bill of Rights only says before you're interviewed, before the interrogation takes place, you're notified. Now, under professional standards, the gold standard for what we should be doing, we notify the accused as soon as the investigation starts. But the law only requires it before you're interviewed. So that's an
This is
important
That's
nuance
kind of
there.
the Weingarten standard, right? We're kind of going to tell you
Weingarten's
it's a
more about
disciplinary
the right to have a
interview.
union rep with you.
No, but we're telling them at least that this is a disciplinary interview, and we're at least telling them it's a disciplinary interview,
That,
I
and
guess.
that does, you're right. You're right. That does become an issue because sometimes all they know is the firefighters called to headquarters, called on the so-called carpet
Right.
and ask questions without really knowing what it's about. So this kind of puts the kibosh on that. One thing I would like to see in Firefighter Bill of Rights is that some of this applies to all firefighters, not just the accused. These rights only apply to the person who is potentially in jeopardy. It doesn't apply to somebody who's just a witness. And I think some of these, not all of them, not so much the notice requirement, but there's other things in terms of the duration of the interview, being told who is asking questions, who else may be in the room. Those types of general courtesy things ought to extend to all firefighters. But again, it's a good start, I'll tell
And
you.
this, I'll throw out the other couple ones. So the interview of the accused has a right to be recorded, which is a good
So
practice
important.
anyway,
So
right?
important. Yeah.
The right to have a representative present, that's really Weingarten, right, during
Right.
the interrogations.
It doesn't go as far, it doesn't say like a right to a union rep, but it does say a right to an attorney. And this is a problem in many jurisdictions that have collective bargaining where you have a right to a union rep, but you don't have a right to an attorney. And that can be a problem in some jurisdictions, not everywhere, but there are certain situations, particularly where a firefighter is accused of committing a criminal offense on duty, where they need an attorney. They don't need a union rep. In
Right.
fact, having a union rep there can make it difficult because before anyone goes into an interview with a union rep, the union rep should know generally what happened. And if the employee has committed a criminal offense and tells the union rep they committed a criminal offense, the union rep can be subpoenaed before a grand jury and into court and required to disclose it. That's why it's so important
There you
that
go with Garrity and all those types of
absolutely. So
issues.
it's so important that firefighters, when they're accused of a criminal offense, no, this is no disrespect against the union officials. I have utmost respect for them, but there's this potential that a well-intentioned union rep now can be subpoenaed before a grand jury and have to spill the beans about what the firefighter told them.
And, and as I'll keep going the last three rights, but it's interesting because a lot of these are already law, perhaps, whether Weingarten, whether Garrity, right? FLSA, the right to be compensated when questioned, even when off duty. Clearly an FLSA right didn't need to be in the Bill of Rights.
You would think, but there are some departments that feel they have the right to call people in on their days off for an interview and don't have to pay them.
Bad idea, right? The right, if formal charges are brought, to receive written departmental charges in advance of a disciplinary action, of course, specifying the alleged misconduct, dates, witnesses, and the rules alleged to have been violated. Very important. And finally, the right to a pre-disciplinary hearing before the fire chief. That's part that I thought was weird, before discipline is imposed.
Well, usually the fire chief is the one that has the discretion to impose discipline. That's usually the case. Now, there are some, particularly in fire districts and some other volunteer fire companies, where it may go to a discipline panel or the board of trustees or something of that nature. But in most jurisdictions, the CEO of the organization, which is the fire chief, has the authority to impose discipline.
And I would have thought it, and maybe it does. I didn't look at exactly, does it have, well, if the fire chief's a witness, then it goes before someone else.
And then there are certainly situations where the fire chief needs to recuse him or herself. Absolutely. If they're a witness. Another one, and I use this in the classes, is where the fire chief is the quote unquote complainant or the quote unquote victim, where a firefighter has been insubordinate directly to a fire chief. He has to step away from that. It's just like if you punch a judge, or you rob a judge, you can't go before that judge and get a fair trial. You've got to have another judge. Not that they're going to be any more sympathetic, but you can't have the person who is the victim or the complainant serving as the adjudicator.
So, and then of course the all important, you can't retaliate for participating in the hearing, which is important. And that's normally what we see in some fire departments, right? Where the people who are looked at as rats or whatever, they participated, they gave truthful testimony, and all of a sudden they're getting retaliated against in some way. So you have the right to be free of those, but it's an important step. Clearly.
It is. And one, sort of big picture thing here, most fire departments that have a Firefighter Bill of Rights copied the language from the state's police officer Bill of Rights, and that's a big mistake. Many of the police officer Bill of Rights were written in the 70s and 80s. They were not very well written when they were adopted. They don't represent best practices today. And I think politically, it might be politically expedient to go to the legislature and say, just give us what the cops have. But a lot of times what the cops have doesn't work for us. This is an example of a really well done Bill of Rights that I think serves the greater good. Management, it helps management, it helps the firefighters, it protects the firefighters. And I think it's an important step forward.
Right. And noticeably important to everybody, these Bill of Rights they supplement, right? They can enhance, but they never downgrade what's in a collective bargaining agreement, right? They can't take away any rights. So if the CBA
usually
is more,
they don't. I mean, push comes to shove, you're dealing with state law, so there's a question of which law is going to apply. Is it the collective bargaining agreement, which flows from the state collective bargaining act, or is it going to be the Firefighter Bill of Rights? So. But usually this would take precedence.
All right, let's go to Los Angeles. We've covered this story before. This is, or no, we haven't covered the story.
We talked about it. We have talked about it, and now the claim has been filed. So
yeah, well, it's interesting. Let me just report the facts again. So this is what's often called a notice of claim or notice of intent to sue. It's not the lawsuit itself. It's the required statutory precedent to the lawsuit. So you got to give notice on what you're suing for. And here, the former Los Angeles fire chief, Kristin Crowley, has filed what I'll call notice of claim or notice of intent to sue against the mayor and and against the city. It was just filed right now in August 25. So she alleges that the mayor retaliated against her for speaking publicly about budget cuts and resource shortages. Ultimately, I'll jump forward. The reasons became a big deal, and then I'll fill in the facts, is because, or the allegations, is because the mayor then, for some reason, takes a 180 and starts coming after the fire chief as a result of was the Palisades fire that burned down the whole, county, and starts blaming the chief, despite the fact, as alleged by the chief, that, I told you we're short on staff, we're short on equipment, right? We are, and you then cut the budget. And here's the thing, the chief was very vocal by her own allegations about the budget cuts, et cetera, which puts the chief in a hard position, right? You got to advocate for your department, but you report to your mayor. What are you supposed to do? Many of us, like me and others, have lived in this where your mayor is your employer, but your mayor's doing things that you're supposed to support, but they're cutting your budget, which you can't support.
I know. I'll speak as far as one mayor goes that told the fire chief point blank in my presence, "Your job is to take a bullet from me." That's the politician's approach to who a fire chief is. Your job as the fire chief is to take a bullet from me, so I don't have to take it. And
I don't know whether it's right or not. And the problem is, in the fire service, we are so used to the chain of command since day one, and the fire chief's boss is the mayor or the council or both. Here the budget was cut by $17+ million. How does the chief advocate for that type of cut? And when she was vocal about it, she claims she was later defamed and publicly blamed, and then demoted. So she's now going after the mayor for, it looks like, right, defamation, retaliation. It's going to be very interesting because now I have no case law on this whatsoever, but I want to throw out a thought, right? Not trying to predict, just trying to say what the issues are. In the employment context, defamation is more tolerated in the courts, by my experience, than it would be if I call out somebody else and say, "Oh, you're accused of a crime," or whatever, because it's mostly opinion testimony. For example, what you're doing is dangerous. Well, that's right. That's an opinion, and opinions aren't defamatory. And policies, why policies are enacted, are not necessarily defamatory. So, but when the mayor is defaming her for her job, that's his opinion of how she was doing, and blaming her is his opinion that it was her fault. So that's very tough to win. I will tell you, I've sued 3 defamation cases in my life, in my 30 years. And the reason there's only 3 is because I never won. And every single time it's, well, that was their opinion. It is very hard to win a defamation case. And in the employment setting, it's probably twice as hard.
Well, and the mayor is going to be a public figure. And now we go to the New York Times standard, which requires really a conscious disregard for the truth of falsity, either known falsity or conscious disregard for the truth of falsity of the statements. So very hard to hold an elected official. Not impossible, but
hard.
Very, very challenging. So we'll see. We'll see how it all shakes out. But I know there were a number of news outlets reporting this was a lawsuit. It's not a lawsuit. It's a claim. I'm not sure how long they have, usually 60, 90 days to consider it.
Usually 90 is the standard I'm used to, but.
So, and then if they don't accept it, then she has the right to sue.
Right. So I don't know. My bet is 80% she's not going to be successful. Not denigrating the truth of what she's saying, just on the law, it's so hard to win. Retaliation, she may have a much better chance for, right? But because, being demoted is unquestionable. But if she's successful on the defamation, this will send shockwaves through a lot of, municipal chiefs' relationships with their superiors. So that, kudos to her. I hope it works out. But nonetheless, I'm doubtful of it. Okay, let's go to the, we are at the Fourth Circuit. We're going to Lynchburg, Virginia. and we have a firefighter demotion case. So this, I like the holding of this. I really do. We get to quarterback it, but I like the holding. So we have the United States Court of Appeals, the court, above the trial court and right below the U.S. Supreme Court. And they mostly affirmed, but some they sent back to the trial court, a case of which involved the demotion of a Lynchburg, Virginia firefighter who alleged sex discrimination, retaliation, and violations of the Virginia Whistleblower Protection Act. We have a firefighter, let's call her Mary S., right? Mary S. was placed on administrative leave with pay, right? Which we've now seen another court say that is not discipline, about a month ago, after she raised concerns about comments to a subordinate, right? So she told somebody under her about the sexual orientation of a team member. Now, first of all, right off the bat, I don't care how this turns out. Don't talk about anybody's sexual orientation. End of story. I don't care what rank or no rank you are. Just stop. Right. But she, I guess she raised concerns to a subordinate. Her superiors were informed that she had instructed a subordinate to inform her of the homosexuality of a new team member if it bothered them, right? Or if it was offensive to them. I get we're in Virginia, not California, but Jesus, right? I mean, this is tough. Anyway, so in response, the deputy chief, properly so, opens an investigation whether she had violated the city's code of conduct and harassment policy. And then I like what the city does, and multiple times, right? They retain a retired Virginia State trooper to investigate, right? Which is the right way out of the organization. I like this in this case. It's not personal now, right? And pending the investigation, she was on administrative leave with pay, which is not discipline, we've seen a court say. The trooper then interviews 14 witnesses, and troopers are good about their interviews and recording and documenting it, completed a report, and concludes, which I think is a bad word, right? I don't know if investigation should conclude, but in any event, where there have been clear violations of department behavior, unprofessional behavior, and acting beyond the scope of authority by the city's policies. Then when the chief received the notice of that investigation, the chief sent Schumer a notice announcing his intent to demote her and provided her with the opportunity to show cause why she shouldn't be demoted. She then goes through and files retaliation claims, etc., to which the city, second kudos, appoints another neutral investigator to investigate the retaliation claim. In any event, the court comes out and says, listen, and this goes back to the McDonnell-Douglas burden shifting, right? She claims, well, I was being treated differently than male employees. The city then comes back with, and the court agreed, the appellate court agrees as well, that, listen, they had an independent reason that had nothing to do with your sex, gender, etc. On, right, you being a female, doesn't matter how males would have been treated in this instance. They had an independent reason and a valid reason for the actions they took against you, which is what the investigation concluded. So the court upholds that. What the court does, though, is the lower court had said, well, on the whistleblower claim, based on the immunity of the government, sovereign immunity, you can't proceed under whistleblower. The appellate court says, no, sovereign immunity is not a defense to whistleblower protection, and nor should it be. That's the whole point of the whistleblower statutes. I'm surprised the district court missed that this is not a novel ruling. There have been a number of other cases, you probably know better than I, but there are a number of other holdings where whistleblower protection is not protected by sovereign immunity, and sends it back to the district court, say, okay, you're not immune, so now analyze this from the beginning. It was the right holding, a sharp holding, but I really want to pull out what the city did to investigate it. This holding didn't come around by happen chance. It came around because the city properly investigated in a neutral and complete way each and every claim and got an independent, fact finding. I thought that was the right way to handle it. And that's why you end up, you said it, I said in your lecture, right? And you talked about, Curt was in Florida and I joined him to get to observe for a couple hours. I wish you could stay longer, honestly. And, what you talk about is the lawsuit doesn't start at the filing the complaint. The lawsuit starts right back near the investigation, et cetera. And this is just the perfect example of that because they got it right from the beginning. They don't have to rely on the lawyers to fix the wrongdoings later on.
Mhm.
Nope.
Well said.
I guess I'm good. Now let's go to Massachusetts. I know Holyoke, a good friend of mine grew up in a Holyoke. I don't know. I guess I got mixed feelings about this one. You tell me. We have a building owner who sues the fire prevention captain. Let's see if I can summarize this. So there's a building, commercial building. The owner has a commercial building. There's a fire in it, which shuts a lot of it down, including the boiler. The boiler doesn't work. Well, winter comes. The building owner doesn't want the pipes to freeze. So allegedly, calls the fire department and gets an oral okie dokie to shut the sprinkler system off. Now, some people are going to be saying, no way in hell. They would have said you had a watch, right? You need a watch on that. Others would have said, maybe it's truthful. I think we all learned, get it in writing. Then there wouldn't have been an issue. But now it's a question of, did anyone tell them that? In any event, so they shut because there's no heat to the building, they shut the sprinklers off. The city comes in, issues violations, and takes control of the electric and such so that the electric heat, which the building owner put in, can't even be operated. So now the city is basically, I think he's saying, the city is basically saying, listen, you told us we have to have sprinklers, but you turned off our electricity to heat the building, and now we can't get the sprinklers going without damaging the building, and then sues, and I would too. I think is the answer to that. I don't know if you have any thoughts on it, but that's just
I wanted to include it in the cases that we talked about this week, just because it's one of those you don't see it all the time. Fire prevention folks have to make these kinds of decisions. Are we gonna give them an extension? Are we gonna grant them a verbal permission, or are we gonna have to issue a citation? I think we'd be remiss if we didn't include cases like this in the in the blog and really in our discussions. They are happening. They certainly are not the most frequent type of case that we see, but we do see them. And like you said, I mean, get documentation. And I think that the building owner may be trying to take advantage of the busyness of the fire department in terms of dealing with it. It did take several months for them to actually issue a citation. It looks like it was June before the citation was actually issued. But certainly there were some building code issues beyond the fire code that sort of led to the condemnation of the building. So why they went after just one particular captain and not the remainder of the building inspector and the electrical inspector and the mechanical inspector and so on, I don't know, but looks like they're like in some of the other cases, we got a lot of finger pointing, like the Los Angeles case, same thing. Oh, it wasn't me, it was hers. Well,
and so, on the owner's
fire
point,
marshal.
Owner should have got it in writing, and the fire department shouldn't give that advice unless it's in writing. Maybe they have the policy on that. Maybe they never gave the advice. Who knows? And then my favorite of all for
you saved the best for last, huh?
Yeah, I did. I went a little out of order because I just think it's too funny not to. So we're down in South Florida, and it's funny. My wife and I, because we're down in Florida, my wife and I are laughing our proverbial butts off because of this. So, and I give. Well, here's what we got. We got very simple. We have an off-duty firefighter in Southern California who's caught on camera stealing an American flag. But how he does it is why I'm laughing. So he's apparently lives down the canal. This is Broward County. So he lives down the canal. He's having some dispute with his neighbor, but he swims across or through the canal. I think across because he must be hearing his neighbor's noise or something pisses him off. For some reason, he swims across the canal. I'll get to that in a second. Gets out, caught on camera, taking their American flag. I don't know.
There was two swims. There's important to understand. There's two swims. His first swim was to swim over and berate or whatever. He has a conversation with his neighbor, and they end up turning the music down. But apparently, I'm assuming there must have been harsh words. I would think that this, in the absence of harsh words, this second part doesn't make sense. Okay. But later in the evening, he swims back across and takes their American flag down. And then he's caught on video swimming back. He's caught swimming, climbing onto the dock, grabbing the flag, jumping in the water with the flag, and swimming across the canal with it. And to me, I think folks have got to realize that virtually everything we do today
It's on camera.
is caught on video. You know, you just.
But here's my thing. Kudos to that firefighter. Only for the reason of, are you freaking nuts? You went through a canal in Florida. Every body of water, if it's fresh water, has got an alligator. If it's salt water, has got a crocodile. And they don't give a shit whether you're carrying an American flag or not. They are going to eat you. And this guy does it not once, but twice. I cannot believe somebody swam through a canal.
I do know a number of Floridians, and they are very bold with their courage. And they, if they want to jump in the water, they're going to, damn it all, they're going to jump in the water. And
theft of property, and how do you value the flag? I mean, I guess it's a misdemeanor. It's definitely less than $1,000. But why are you defaming the flag? Why are you taking their flag and then defaming their flag?
Well, and that's what leads me to believe there must have been harsh words. It wasn't just, "Hey, could you turn the music down?" "Oh, okay, thank you," and back in the water. There had to have been some sort of confrontation there that did not end well. And
but to steal their flag, I mean, toilet paper their tree or something, maybe.
Well, I mean, he was charged. I believe that one of the charges was felony burglary.
That's what I don't understand.
He
didn't break and enter. I'm presuming the flag's on the outside of the house. So burglary is basically breaking and entering. There's
with intent to commit a felony therein.
Yeah.
or a criminal offense in some cases, but
misdemeanor larceny, I get. I don't know where the felony burglary came from, but anyway, and inevitably he's going to be disciplined by his fire department. So why risk your job over a neighbor dispute?
I also have a feeling there may have been some either alcohol or recreational things going on there. It doesn't, as it was presented in the news media, one and one equals four here. It's not adding up. So I think there was some other things going on, and
It is very weird. In any event, that is our week. What a great week. I love ending on highs, no pun intended. And so hopefully you are safe down where you are and you come back not in,
I am safe. I am surrounded by people with guns. So every place I go, there's people with guns. So it's
hopefully the right type of guns, not
crazy place, man. Crazy place. So, but at any rate, I will be back home next Monday. So we should be back to normal. So
very good. I'm sure we'll have another exciting week.
All right. And that'll do it for another edition of Fire Law Roundup. We'll see you all next